up, it's Julie. Welcome to my channel. In this video we're going to look at the third thing you need to think about in the tort of negligence, and that is causation, or the but-for test. So we've already looked at whether someone owes a duty of care to someone else and whether someone breached their objective standard of care. Now we're going to look at whether someone's actions actually caused the damage. Let's get started. When trying to figure out whether someone's action caused the other person damage, you're thinking about this. Here's the defendant, here's the plaintiff. Did the defendant directly cause the plaintiff to have the damage? So in other words, it is but for the defendant's action, would the plaintiff have suffered damage? So there are a lot of things to think about with this test. One example is from this case, Barnett and Chelsea. And in this case, a nurse told someone not to take a certain drug that they should have taken, and that person then died. However, that person would have died anyway, regardless of whether the nurse told them to take the drug or not. So yes, the nurse was negligent, they should have taken the drug, but the nurse's action didn't actually cause the person to die. So the nurse was not held responsible for that person's death. Also in the case Mick Williams and Sir William, someone was doing some sort of scaffolding job, they didn't have a harness on, they fell and they were injured. And it was held that the company was not negligent for not providing harnesses. And the reason for this was because even if they had provided harnesses, the evidence showed that the people wouldn't have worn them anyway. Therefore, not providing the harnesses did not directly cause that damage, as there was no causation, as even if they did provide the harnesses, the people wouldn't have worn them anyway. There are some instances where the but-for test does not work. So imagine there was one person and there were two people over here and both people shot this person at the same time and that person died, and it could not be shown whose bullet caused this person to die. Would that just mean that no one is responsible? That's not quite fair, right? So the new test is from this Fairchild case, and the test is if you materially increase the risk to this person being injured or dying, then you are responsible. So that would mean that these two people who both shot this one guy are jointly and severally liable for this person's damage. That means this person can sue either one of them or both of them for all or part of the damage, and then if, let's say, you only sued one, then these two people are responsible for suing each other to make it fair and distributed between them. The Fairchild and Glenhaven case, this person was working in all sorts of jobs where they were exposed to asbestos and they got cancer or some sort of illness from this asbestos, but it couldn't be proven which employer specifically exposed this person to asbestos, as they all exposed him. So basically it was held that they are all jointly and severally liable, as they materially increased his chance of getting this sort of illness by exposing him to asbestos. Something you have to watch for is a novus actus interveniens, and that is when something negligent happens and this causes something else to happen, but this something else is not a direct and natural result of this first thing. Okay, so basically what that means is something else has gotten in the way and broken the chain of causation, which has stopped this person from being liable. An easy way to explain this is if we look at the Dorset yacht case, which we've already talked about in a different video, but that is where there were some juvenile boys on an island and some guards were negligent and they weren't really watching them, and the boys escaped and caused damage to yachts nearby. So in this case, the guards being negligent caused the boys to escape, and it was held that there was no novus actus interveniens because the guards negligent directly caused these boys to escape. Or in other words, as a direct and natural consequence of this negligence, these boys were going to escape. But let's say the guards were negligent and somehow the boys escaped, and then somehow these yachts, let's say, sailed their way to the main island, wherever that is, and then on the main island someone saw this and caused some fireworks to go off, and then these fireworks hit into a lamppost and that lamppost fell on a factory, and then in the factory heaps of damage was caused, which then started a fire. So you're kind of getting where I'm going for, right? So all these acts in between would be breaking the chain of causation between these guards and, let's say, the fire in a factory on the main island. And this is, there's no chain of causation anymore. It's not that the guards, as a natural and obvious result of them not watching the boys, that this fire was going to start in this other place. Alright, and that is the causation element in negligence. If you want to see more again, please look at my blog post. It's got way more cases and way more information, and that link is in the description below. Please like this video if you enjoyed it, and subscribe to my channel if you want to see more about law and studying in general. Also, if you want to see more about negligence or tort law in general, please look at my channel for more information. Alright, thank you for watching and see you next time. Bye!